are the parties in an estate? When a person dies, their estate often must go through probate, which is simply the legal process of having assets distributed to estate beneficiaries. Multiple parties are typically involved in these proceedings, including heirs. The heirs are the family members who would be legally entitled to receive some portion of the deceased person's assets if they died without a will. 2, beneficiaries. The beneficiaries are the people who are entitled to receive a portion of the deceased person's estate according to the terms of the will. 3, creditors. The creditors are the people or businesses to whom the deceased person owed money when they passed. And 4, the personal representatives. The personal representative is the person who's appointed by the court to administer the estate. The personal representative is often the executor named in the will, but they can also be an administrator appointed by the probate court if there is no will. Each party has different rights and responsibilities in an estate, and it's important to understand these roles before moving forward in any probate court legal proceeding. If you have questions, give us a call, shoot us an email, or schedule a free consultation at rmolawyers.com. Who are the heirs of the estate? The heirs of an estate, sometimes also known as the heirs at law, are typically determined by the state's intestate succession laws. If someone dies without a valid will, intestate succession determines who is going to inherit the estate. Generally, the estate's going to go first to the surviving spouse and children. If there's no surviving spouse, children, or grandchildren, the estate then is going to go to the deceased person's parents. If there are no surviving parents, then the estate will go to their siblings. If there are no siblings, then you go to the next of kin, so on and so forth. Who are the beneficiaries of the estate? The beneficiaries of an estate are the individuals or organizations, charities, etc., named in the will as being entitled to receive some portion of the estate assets. In many situations, the named beneficiaries of the estate will be the same as the heirs at law to some degree. However, people can choose whoever they want to be their beneficiaries, including charities, non-family members, friends, acquaintances, distant relatives, etc. It's also important to note that the beneficiaries named in the will are not necessarily entitled to receive equal shares of the estate assets. The distribution of property is typically based on the wishes of the decedent and can be influenced by any number of factors. If the deceased person didn't leave a will, then the assets are going to be distributed to their heirs according to the intestate laws. Who is called an executor of the estate? An executor of the estate is a person appointed by a deceased person's will to administer the estate. This includes distributing the estate assets according to the decedent's wishes, as set out in the will. The executor is responsible for carrying out the will's terms and ensuring that the deceased person's debts are paid. They may also be required to sell property in order to raise funds to pay debts or distribute assets to beneficiaries. In some cases, the executor may also be responsible for managing the deceased person's financial affairs during probate. If the deceased person did not have a will, the court is going to appoint an administrator instead of an executor to handle the estate. Just like an executor, the administrator is responsible for administering the estate and ensuring debts are paid and all assets are distributed according to law. Both executors and administrators are commonly known as personal representatives of the estate. What's included in an individual's estate? An individual's estate includes all of the probate assets that they owned at the time of their death. This includes individually titled property that does not have a joint owner with a right of survivorship or a designated beneficiary, like a retirement account. Some assets will automatically transfer to the joint owner or beneficiary on death. Property that's held in a trust also is not going to be included in a deceased person's estate. Property that is not part of an estate in California includes 1, jointly owned assets with survivorship rights, such as a joint bank account or jointly held real estate. 2, some investment accounts, including specifically retirement and some brokerage accounts that have a named beneficiary, or if they too are owned in joint ownership with a right of survivorship. 3, death benefits from a life insurance policy with a designated beneficiary. Or 4, property that's held in trust. Can I contest a will or probate? Sure. Heirs, beneficiaries, and other interested parties can contest a will or the probate of that will if they have a legal basis for doing so. Undue influence is one of the most common grounds for challenging a will, and undue influence occurs when someone exerts pressure on the person who created that document to such a degree that they overcome their free will, and they essentially take actions that they wouldn't have taken if they weren't subject to that pressure. Duress is another common ground for challenging a will, and duress takes place when the testator is threatened with force or violence unless they create or sign the document at issue. Likewise, for a will to be valid, it must be executed by a person of sound mind. If it can be shown that they lack capacity and didn't really understand what they were doing, or that they weren't able to understand what they were doing, the will might be invalidated for lack of capacity. There's also fraud, forgery, coercion. Those are separate grounds for challenge, as is failure to comply with all of the legal formalities required to create a valid will. The probate court may invalidate a will if any of these can be proven. However, succeeding in a will contest can be challenging, so you should be sure to discuss your situation with an experienced probate litigation attorney who can help guide you as to what the next best steps are. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation at rmolawyers.com. Thanks for watching.